even in the draconian legislations that we've had, right? Be it TADA, UAPA, or POTA, now all this extraordinary detention is now applicable for all offenses in the BNS, right? Be it theft or hurt or whatever.
The principles on which criminal law is drafted across the world, it doesn't matter which regime we are in, is precision, certainty, and clarity. If precision and clarity is missing, that in itself is an assault on my liberty.
What we really need to recognize now is that we're going to have to run two parallel systems of administration of criminal law. One with, and there's going to be a lot of confusion. There's a lot of confusion in High Court jurisprudence already in terms of what procedural law will apply.
Hello and welcome everyone. It's 1st of July and the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshya Adhiniyam have effectively replaced the Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act today. As a historic page turns, we are discussing today about what this means, what the new laws actually bring in, and is it really an overhaul of the criminal justice system as we know, and what are we looking at for the next few months? You know, there are a number of teething issues that are already being flagged every day. States have raised some crucial concerns about these laws, where actually the laws will be put to practice and tested. So we have with us Senior Advocate Vrinda Grover and Professor Anup Surendranath from the National University of Delhi. Vrinda, if I could start with you, one key issue that a lot of states have been talking about and seems like where it really pushes the envelope is where the Bharatiya Nyaya Sanhita includes under its ambit a whole bunch of new laws, right? From terrorism to organized crime. So, and we have special legislation for all of these, but now all of this coming under the regular penal code. What is its impact and what do we make of that?
Well, this is a very, very grave concern, and it is actually what it will lead to is legal mayhem in the organization of where cases should go, which is the investigating agency, because under UAP, as you know, there are special investigating agencies, etc., special designated courts, as well as enlarge the arbitrary powers of the investigating agencies at a time when there is already a very serious criticism in the court, including in judicial verdicts, that investigating agencies implementing special laws, particularly the Unlawful Activities Prevention Act and the Prevention of Money Laundering Act, there is a lot of arbitrariness, excessive use of law, false implication, politicization of the law, to have picked up Chapter 4 from Section 15 to 21 of the UAPA verbatim and copy-cut paste it onto the Indian Penal Code. The UAPA is already a very stringent, in fact, a draconian law brought in under emergent circumstances. And that is the justification that the state gives when it brings in laws of that nature. In the statute, there are some checks. Whether they operate or not is a separate debate. But the provision for sanction, review committee, etc., the statute acknowledges that there is going to be a very wide ambit that they will cover. Section 16, for instance, talks about conspires, advises, abets. There has been repeated comment that already this language is very overbroad, vague, and generic. Now to bring that into the ordinary law, one, what it creates is the routinization or the normalization of anti-terror law provisions, which are no longer then seen as exceptional, extraordinary. They become part of the ordinary law, and it is now left to whom? To the police, to the state, to determine whether I will go under UAPA or I will go under the Terrorist Act, because there is no threshold, penal threshold distinction left. And this is it's something that should have by now actually got comment not only from many lawyers, and bar associations are the only one who are speaking out, but I think this deserves much more grave attention by parliamentarians as well as by members of the judiciary.
If I could ask you, in practice, how do you see this working? Because the UAPA is not repealed. There is still that legislation. And if anything, the punishment under the Nyaya Sanhita is actually enhanced with the fine components. Whereas the jail sentence is the same for both. So if a person is booked today for, say, an unlawful activity, which law are they charged under? Or is it both?
The FIR and the charge sheet can be filed by the police. Finally, cognizance will be taken and charges will be framed by a court of law. So that part, at that stage, in any case, some amount of reorganizing and reshuffling depending on the prima facie material that the prosecution investigation brings to the court takes place. But today you are actually, what you have done is you have given, legitimized the arbitrary abuse of power by and vested it in the hands of the local police station.
Yeah.
When people are arrested under extraordinary laws, it actually draws a certain, and I think this is a finer point which we perhaps may want to consider, it attracts a certain kind of attention, both within the country as well as globally, because countries, we know after certain events globally, anti-terror laws are given justification, etc. And there is a lot of conversation in this country about the manner in which UAPA has been used. Now you're saying, all right, we're not implicating them under UAPA. We're just picking them up under the ordinary law of the land. And that normalization and routinization of anti-terror provisions, which are totally in contravention with freedoms and liberties, and now is left entirely to the local cop to decide where to park you at a time when there is documentary evidence to suggest that there is no even-handed application and operation of law. There is partisanship in the manner in which the law is being applied. We are therefore opening the door to a very dangerous trend.
Anup, this is something that you've talked about before, you've written about, but can you tell us what is the change in law on pre-trial detention now? Why is that a cause of concern?
I think for me, that's the extremely grave area of concern in terms of how much detention is being authorized under Section 187 of the BNSS, and how do we read the provision on. And I think there is significant confusion, and I think two readings are possible there. And this is not the sort of thing that you want to leave confusion on, right? So one reading is that the current law that police custody is maximum available for 15 days and has to be taken within the first 15 days. One reading, and then that is provided in 187.2. There's no doubt about that this 15-day period now can be extended over a much larger period of 40 or 60 days. And that, so the 15 days can be spread over. So there's absolutely no doubt about that, right? Where there is confusion is that even the total 15 days, can it now be 60 or 90 days of police custody? In 187.3 of the BNSS, there are significant words from the existing 167.2A proviso that has been deleted, right? In the current existing CRPC, you can be given custody beyond 15 days, how many days of custody? The custody other than police custody, right? Those words.
So that would be like, say, you being lodged in jail, like in
jail,
judicial custody.
Yeah, you could be sent judicial custody, which is to send you to prison and not leave you with the police. There it says beyond 15 days, you can be sent to custody as long as the custody is not that of the police, right? That is the current law. Now, those words have been explicitly deleted in 187.3. Now, how do you read 187.2, which says you can take the 15 days over a longer period, versus how do you read 187.3, which now seems to suggest that either custody is possible, police custody or judicial custody, I think this is dangerous confusion. These are not the kind of things on which you want to leave doubt, right? And now what is happening is that, as Vrinda was saying, even in the draconian legislations that we've had, right, be it TADA, UAPA, or POTA, now all this extraordinary detention is now applicable for all offenses in the BNS, right? Be it theft or hurt or whatever, right? It is now, you have, even if you take the more limited point that 15 days can be extended over a larger period, or the confusion that it's not just 15 days now, it is much larger number of days, you have extended it to all regular offenses. It is no longer an extraordinary measure, right? And then the sort of normalization that Vrinda was talking about, its most potent articulation is in this confusion. Yeah.
So it is then left to the magistrate, and depending. Yeah, sorry, Vrinda, you will.
Yeah, Vrinda.
So actually, I totally agree with Anup when he says, how can you leave confusion in such a basic provision which has to be applied in every person who's arrested? Yeah, this will apply to. So it's not some one particular, or it doesn't matter, we don't need to look into it. This is basic fundamentals of the criminal legal system, which I refuse to address as criminal justice system any longer, for the police and for the magistrate and for the lawyers, and whether you're prosecutor or defense, it doesn't matter. To allow this kind of confusion to remain in the drafting is actually unacceptable. The principles on which criminal law is drafted across the world, it doesn't matter which regime we are in, is precision, certainty, and clarity. If precision and clarity is missing, that in itself is an assault on my liberty. And we know Article 21 has spoken extensively about human life and human dignity, etc. I believe, and I've actually accessed the BPRD, the Bureau of Police Research and Department's manual that they have created for the Delhi police.
This is a training material that has been used for
That's
police.
Right. So this is BPRD's, which is a premier agency, for what they have provided to the Delhi police. So, that would be my reading of the law, despite the drafting chaos, is that 15 days staggered over either 40 or 60 days, depending on the nature of the offense. The total period of police remand, police custody, will not exceed 15 days. And they say that in the comments in the BPRD training manual very categorically. Having said that, what are the implications of this for both for personal liberty and for personal integrity of the body? Both the fear of this kind of police remand after a later period of time keeps coercion, duress alive in the mind of the accused. And we have seen how people are turning approver, how people are changing their statements, the fear of torture, the fear of continued detention. So the manner in which that can be abused is already playing out even before these laws. This law has now today come into play. Secondly, you are, although they have said in the provision under 187 that merely because you are again going to be required for police custody will not be the sole reason why bail will be denied. However, in practice, how will it play itself out? It is so casually that applications for remand are moved, and that again has been a subject of judicial operation recently, where you will just say, oh, I need this person again for police remand, and he's likely to tamper with evidence, he's likely to influence witnesses. So we are effectively foreclosing bail for 40 or 60 days, depending on the classification of offense. So personal liberty is directly hit by this provision.
No, another procedural issue that really raises concerns is something that where police officer is given up to 14 days to conduct a preliminary investigation before filing the FIR. So I want you to tell us why this is so important. Why is it so important for an FIR to be filed immediately?
So Lalita Kumari Constitution Bench judgment of 2013. And that's what I'm saying. There are multiple provisions here which are in defiance of Supreme Court judgments. And that in itself should be a matter of grave concern. One would expect Parliament to pay heed to what the court is saying. What we have seen in this country for all manner of offences is that FIRs are not lodged, and it leads to corruption, it leads to all other kind of abuses. And therefore, Lalita Kumari's law, which has been reiterated now by the court umpteen times. Now, and a few offences were carved out in which a preliminary inquiry may be conducted. Now, what we are seeing is that for any offence where the sentence is more than 3 and less than 7 years, which are cognizable offences, it is up to the police to ascertain whether a prima facie case is made out. And prima facie is a very high threshold. Prima facie is the threshold that is going to be at the cognizance stage, where the judicial magistrate is going to take cognizance of an offence. That is not the threshold on which an FIR is to be lodged. Prima facie will emerge out of the process of investigation. Again, what is therefore left is arbitrary power, very enlarged arbitrary power to the police, which had been curtailed by the Lalita Kumari judgment. Again, police has acted with bias also against specific communities, we know. So we have to keep all that context in mind today. And this will lead to heightened corruption. It will lead to delays where evidence and investigation may be very time sensitive. And it's totally, there's no explanation why this has been introduced at this juncture, because all the judgments and experience speaks to the contrary.
Just for a common audience, tell us what are the perils of a delay in filing an FIR?
So I can go with a complaint and say that X offense is committed. If the offense, and I say somebody has attacked me, I may not have any physical injuries. By physical injury, they'll say, okay, there is prima facie, but very often the attack may not lead to physical injuries. I'll say, this is the offense that has been committed. Please lodge the FIR and commence the investigation. The police will say, we are not sure whether you've really received this kind, whether there has been this attack. We will first conduct a preliminary inquiry, which can go on till 14 days. And that is to ascertain whether a prima facie case is made out. Supposing they come to a determination that a prima facie case is not made out, what are the legal remedies? You can then go file, write to the superintendent of police or the equivalent in Delhi, etc. Or you can go and file a private complaint. The private complaint procedure has also been altered in a way which is going to lead to huge delays and confusion. And again, contrary to what the Supreme Court is saying. So you are actually denying persons the right to access justice, the right to investigation. So to say that, we are building this for victims, etc., the fine print is actually working against, and what it is saying is the local police, and it's an open secret. Under whose writ does the local police work? It could be the political master, it could be people who are powerful and dominant in their areas. We are a very vast country. People are living in rural areas. People are living in many, many different spaces in this country. The one agency, the one link of the criminal legal system that across the board there is no dispute, which has been commented upon, critiqued, is the police. And you are enhancing the arbitrary power of the police to decide these things, which the Supreme Court has actually taken out these powers out of the clutches of the police.
Apurva, if I can just...
Yes, sure.
I completely agree with Vrinda here. And look, there's a long history of case law in the Supreme Court, which was a big fight to get to this stage and really start implementing the law that the police do not have a discretion in filing the FIR, right? There is a long history of struggle to that in the Supreme Court. And just with one amendment, with none of us really knowing what is the logic. Of course, nobody has been told the logic of any of this, right? But something as fundamental as this, which is for victims' rights, right? And the idea and why it had such a prolonged fight was that the police was using this to reinforce all sorts of hierarchies and structural inequalities and not register complaints and not register FIRs in the favor of the rich and the powerful and who was suffering. It was the most marginalized, the poor, who were then messed with at both ends of the criminal justice system, both as victims and as accused, right? And so, and I think, and it's, I guess, for the academy also to do this work as to how much of these laws have backtracked on Supreme Court positions, right? Yeah. And I think that is a project to be done and work to be done for sure. And also that this whole victims' rights rhetoric, even if you look at the victims' rights provisions across these laws, they do not go as far as what the Supreme Court case law has already done, right? So the rhetoric of victims' rights is also not one that plays out in these laws. So if you map all what the judgments have done and where this is going, as with most of the other rhetorical justifications, it really doesn't match up. But yes,
Anup, I want to ask you this because victims' rights is not just a populist theme that has come up. We've been seeing this for quite some time, where even court judgments, everybody emphasizing on the right of the victim to be heard in terms of the quantum of punishment in a trial or closing of the case. Tell us how this fits in the framework of a trial, and especially what is a free trial and where does the victim where can we place this?
Right. Look, it is a important and very nuanced area of the law that I think has to develop more. The idea is that the state cannot appropriate and is not the best representative of the interests of the victim, right? That the state can always, in many situations, have a very skewed interest in to what extent and with what kind of rigor it prosecutes, right? And therefore, the state cannot just we should not assume that the state can automatically just step into the shoes of the victims, and the victim have certain set of interests. To constantly be informed what are the rights of participation in a trial at the bail stage, to what extent they can assist the prosecutors at sentencing. So all of these are very important rights of participation in a trial, right? And I think these laws just don't go as far enough as where the case law had already taken us, right? It's rather unfortunate that then now this is sold as pro-victims legislation, right?
Can I just add one thing to what Anup has said? So we already have a victim witness protection scheme, which actually in Delhi, it is the Delhi State Legal Services Authority where you can file an application. And it has the force of the law. And so actually there has been evolution both through procedural law being amended, substantive law being amended, as well as through court judgments. So yes, today you put the witness victim scheme integrated it into the statute, but it was already there in place. Interestingly, people actually, in my own practice experience, people found it better to go to the DSLSA rather than now that power of going and filing for protection is given to the police. So, and we know that Legal Service Authority is one institution that exists right down to the district level across the country and is an interface that would have been better for the victim rather than the police, because we don't know which way, in which case the police is leaning, particularly in cases where the victims are desirous of protection. So, there's a lot of noise being made, but when you go into the finer print, as I said, I just want to add one more thing. So you have custodial violence takes place in this country. It's recorded by the NHRC. And by by judgments. Torture has not been made and codified as an offense. That silence continues in our statute, despite India's commitment at the United Nations, the Law Commission of India's recommendation and the Supreme Court of India encouraging the government to codify torture as an offense. In 2005, an amendment was made in the Code of Criminal Procedure that in the case of custodial death or custodial rape, and in many instances of extrajudicial killings, which we euphemistically refer to as encounter killings, will be deemed to be custodial deaths. And there is a mandatory judicial magistrate inquiry, which earlier was to be done by a magistrate, not a judicial magistrate. Through experience, the Parliament thought it fit to change it to a judicial magistrate, which stands reaffirmed by the Supreme Court in its 2014 judgment of PUCL versus State of Maharashtra, where guidelines for encounter killings are laid down. Please look at BNSS 196 subsection 2, which has just quietly dropped the word judicial. Everything else is there, and brought it back to the pre-2005, leaving it to the magistrate. Judicial magistrates act independent. The whole structure is independent of the government. And that judicial has been dropped. So what we are seeing here is accountability of public servants is being diminished for violence, custodial violence. And you have impunity, which is actually being given an even greater play now.
Yeah. No. I wish we could talk all day about this, and I'm sure we will over the course of the next few months. I'm sure I will come back to you for a lot of these things again. I want to ask you, what is the one area that you see where courts will absolutely have to intervene and sort out the issue immediately? Otherwise, it would be a very chaotic situation.
No, I think, look, I just want to say it's unfortunate that the Chief Justice gave his stamp of approval for these laws in a talk or speech that he was giving. I think it was should have shown better judgment, right? Knowing very well that something of these sort of things would come in for judicial challenge, and it is, I think, inappropriate to have commented on its desirability in public in that sort. But I think what we really need to recognize now is that we're going to have to run two parallel systems of administration of criminal law. And there's going to be a lot of confusion. There's a lot of confusion in High Court jurisprudence already in terms of what procedural law will apply, for certain set of proceedings, that for offenses that have occurred before 1st July, what procedure will apply when one set of procedures have stopped and another set has to start, right? Where until framing of charge, it could be one procedure. After that, what is a procedure? There's very serious conflict of opinion amongst the high courts on this. None of this remains resolved in the repeals and savings provision provided in these laws. And I think in terms of just the two substantive provisions that are of significant concern is the provision on false and misleading information, a very, very wide ambit given to what can be criminalized under that. Nobody really can tell you, if you read that provision, of what you can be prosecuted for false and misleading information is so wide and open. And also the sedition replacement in 152. So this, again, going back to the point that Vrinda started with, it's very, very serious enhancement of police powers, and that coupled with the fact that important civil liberty protections have been watered down, are all very serious constitutional issues that the court, I hope, will take serious cognizance of. And unfortunately, what we have seen is that when even such serious constitutionality issues are raised, courts have been the Supreme Court has been increasingly reluctant to stay them until constitutionality is decided, and then almost allow for its constitutionality as fait accompli, because saying that, now it's been in force for so long. But I hope, given the significant civil liberty implications of this, a different approach will be taken when the constitution, and again, it's already been filed, I think, the constitutionality challenges. So I hope the Supreme Court will take a different approach on this. But yeah.
Yeah, see, it's going to be a difficult period for everyone associated with the criminal legal system for a while. Um, and that is why the question keeps recurring, why? And it's not as though, so I would like to say that I am not against legal reform, legal amendments, and I do not at all think that the earlier laws were perfect. Under the earlier laws, we saw very, very serious encroachment of personal liberty and civil liberties and rights of citizens. So yes, reform was required, but areas where accountability was to be created, those have been left untouched and arbitrariness has been increased. Courts actually will have a greater role to play than ever before, because now the police is getting a statutory alibi for arbitrary exercise of power, abuse of power, misuse of power, targeting certain persons or communities or groups. That has now been enabled. And therefore, the role of the court will become even more important, and not just the Supreme Court, where constitutional challenges will go, and they'll again have to go provision by provision, but also of the first court, the magistrates' court, where the court will have to see whether that exercise of discretion is at all in accordance with principles. Principles of law have not changed. Principles are codified through Supreme Court judgments and in the Constitution. The criminal codes are not standing in the abstract. We will have to reiterate those principles, and courts will have to increasingly rely upon those principles. So we are looking at a time where this, as was mentioned by Anup, for instance, sedition is stayed, and what we have here is an even greater monstrosity now. So there is a very clear danger to freedoms and liberties, and the role of the court will be therefore greater, and conversations and discussions around this will have to be much more robust. And, just wrapping your head around, and I can say that as a practitioner, of provisions which have just been jumbled up to create. So is the idea, what is the purpose to be achieved through legal mayhem that is being created when you're saying we are doing this for speedy justice? Everybody, one is getting cross-eyed now, reading the fine print of the old provision and the new provision to ensure that what you're going to say in court, where are the nuances, where are the changes?
Yeah,
so we are looking at a very difficult period ahead.
The most substantive issues for the numbering as well.
Just to make two quick points on efficiency, right, which has been one big rhetorical argument as well, right? Just to going back to the point that Vrinda was making about the preliminary inquiry point that they were saying. Now, the government, the idea is to say we're going to keep pendency low, right? We're going to keep pending FIRs low. But how? By saying that we won't even file the FIR, right? Because there is no reason for us. So you can see this developing into an efficiency argument as to how we are not going to file the FIRs, and therefore the pendency of investigations has come down. Second, yes, another big selling point has been there are timelines, strict timelines provided in the BNS. Yes, but where is the institutional capacity to deliver those timelines? And B, what are the consequences if you don't follow those timelines are not clear, right? Yeah. Similarly, with video recording of search and seizure, all great, but how to record, where you will store it, who will have access, what will happen if you don't do it. So there's just such a poor exercise in a criminal reform. It's very difficult to call this reform, to be honest.
Yeah,
right?
Of course, it can't be changes just in the books. You have to ramp up judicial infrastructure. There has to be police reforms. And it's obviously not a one-stop solution for, changing the laws and bringing in new ones.
Yeah.
Thank you so much, both of you, for joining us. This was wonderfully insightful, and I'm sure we'll come back to you again. Thank you for your time.